Welcome to the monthly Consumer Issues program hosted by Cornell Cooperative Extension of Tompkins County. On the second Thursday of each month, we're joined by New York State Assistant Attorney General Michael Danaher, who makes a presentation on a topic of consumer interest. Today's program is on home improvement scams. After his presentation, Mr. Danaher will answer questions that viewers have submitted to CCE Tompkins in the Zoom chat box. This presentation also will be available on the CCE Tompkins YouTube channel and will be broadcast next month on Mondays on Public Access Channel 15. Thank you for joining us today. And now here is New York State Assistant Attorney General Michael Danaher with today's program.
Thank you, Sandy. Hello, everyone out there. It's good to be able to be with you today. It's that time of year. It's the time when the weather starts to break and people start deciding on their outdoor home improvement projects that are inevitable, seems like every year. This is one of the areas that our office receives a significant number of complaints about, dealing with frauds and scams. So our hope here today is to give you information so that you can be a good consumer when deciding on a home improvement project, and that you can be wary of certain things that are out there that appear to crop up quite frequently related to home improvement jobs and problems that can occur, so that you can protect yourself and make sure that you're going to have a good and useful project without getting ripped off. So New York actually has a number of laws related to home improvements. I guess that tells you how it's been such a common problem that the legislature stepped in and actually put requirements down in order for for home improvement contractors to properly deal with consumers. So New York actually has, it's in the general business law, we actually have a home improvement contracts law. And there are other laws that impact home improvements, but there's a main section of the New York general business law that governs particularly home improvement contracts. It covers all types of home improvement work. The definition of a home improvement contract is all encompassing. So I think that the best assumption you can make when having a home improvement contract, and this would include those out there that are contractors as well as consumers who are going to hire a contractor to do the work. You should assume that if it's anything to do around the house, above a $500 amount, it would fall within the aspects of the home improvement contract law. There are some exceptions, but go with the assumption. I think that's a good rule of thumb, is to go with the assumption that it falls in a home improvement contract and the laws that govern those. So it's so all-encompassing. It covers driveways, landscaping, swimming pools that you install. It applies to all contractors, and contractors are a huge group, because it's a contractor. A home improvement contractor is one who engages in home improvement contracts for the total price of all jobs in a year of $1,500. Now, I don't know too many people out there that have too many home improvement jobs, or how many contractors out there that even the hobbyist, for the lack of a better term, home improvement contractor, would fall within it if the total price of all the jobs that the home improvement contractor does is $1,500 or more. You can understand that the statute was created a while back when $1,500 was a little bit higher standard than it is today. But especially now, especially today in 2021, with the cost of what I'm hearing, because I actually have a home improvement contract that's going on in my house right now. The contractor that we have was told me that the cost of lumber has skyrocketed. Also, he looked out at our back deck, which is Trex material on our deck, and he said, "Oh boy, the cost of Trex now is so high." So just putting a small deck on the back of one house might be enough to qualify that home improvement contractor as a home improvement contractor under the law. Also, contracts done by a home improvement contractor, so a contractor that has engaged in home improvement contract work totaling more than $1,500. If they enter into a contract in excess of $500, it falls within the parameters of the statute. So if it's a $200 small job, it would the laws for home improvement contractor would not apply as far as what needs to be done. We'll go through those in a second, but it would not apply. But for anything above $500, it does not include cosmetics such as draperies and carpets. It does not include appliances, which would be covered by the appliance warranty that would come from the manufacturer. It would include a custom home. A custom home is a new home built on land by the homeowner at the time of the contract. So it's a little bit different than if the home improvement contractor was building a quote unquote spec home, a home that the contractor owned the land and everything and just built it with the hopes that when it was completed, it can be sold. But if the homeowner has a plot of land and they want to build their dream house on that property, the custom home would constitute a home improvement. Even though it's a home construction, it's considered to be home improvement and therefore would fall within the statute. So here are the rules. Contractors, homeowners should know. First of all, the burden is on the contractor, and that is all home improvement contracts, those ones that we just talked about that fall within the parameters, must be in writing. So you must put it in writing. It's the law. There are heavy penalties to the home improvement contractor if he or she does not put it in writing. And frankly, it makes good business sense. It just makes good business sense. Why would you not do it in writing? There are so many problems that occur in this area and other areas when people do things orally. And one person misinterprets what was said by the other person, and therefore a dispute arises, and there's no good way of resolving it. The legislature enacted this law to say that there's no oral contracts with these home improvement projects. It must be in writing. That way, both parties know whose responsibilities are for what. And again, there are heavy fines associated with not doing it this way. It doesn't just protect the homeowner, it also protects the contractor. How many of you have ever, let's say contractors, how many of you have ever had a problem over a dispute on what work was to be performed? And it might have been because something got changed. And there's often miscommunication between the parties when things get changed, because you originally have the contract, and then let's say the homeowner wants to change something. And the contractor says, yeah, I can do that. Well, what the contractor doesn't say to the homeowners, in doing that, it's going to cost more money. So then they go back and they say, okay, here's an extra $1,000 for that change that you did. Whoa. You didn't say anything about that. So it solves all those problems. Everything in writing, even change orders, put it in writing. And then everybody will know. Many of the disputes that occur between home improvement contractors and homeowners would be resolved by having all the details set forth in the contract. And again, that includes all change orders. Make sure if there's any change, put it down. If it's going to cost more, put down how much extra it is. Both parties sign. Then when you the home improvement contractor presents the bill to the homeowner, there's no question. What's the homeowner going to say? Oh, you never told me it was another $1,000. Yeah, it's right here in our change order that we did. And by the way, get it done ahead of time. Before you do the change, get it in writing ahead of time. So these are the minimum requirements that must be undertaken or must be put in the contract. Name, address, phone number of the contractor. So name, address, phone number of the contractor must be in there. I know nowadays that they'll often put their website, email address, but that's not required by the statute simply because when the statute went into place, there was no email. So contact information for the contract. The date when the project is going to begin and the date when it will be substantially completed must be included in the contract. That lets the consumer know when you're going to show up and how long it's going to take. Many of the problems I've seen over the years is a contractor not showing up on the day that he or she was scheduled. This way, the law requires you got to have a start date, you got to have a completion date. A description of the work that's going to be provided, including any materials that are going to be provided. So you need to include everything that you're going to do. You must also include a notice in the contract to the homeowner of possible lien law filing if the contractor is not paid. And that's the thing that you may have heard about over time. It's a term that gets thrown out. It's called a mechanic's lien. That someone who does work on a property, or in other cases, the like if you're gonna get something else fixed or something, like you go to get your car fixed. If you don't pay for the car, lots of times the place, the repair shop's not going to give you the car back if they pay for it. But let's assume for the moment that you didn't pay and say, okay, I'll pay you whenever. If you don't pay, the workman can get a mechanic's lien on the vehicle. And in this case, they can get, the home improvement contractor can place a lien on your property that tells the whole world, it gets filed in the county clerk's office, telling the whole world the contractor has a lien. And if the homeowner were to sell the property, that lien would have to be paid off, just like a mortgage have to be paid off. The lien for a mechanic's lien, just to give you the weeds of this whole thing, down into the dirt and weeds. A mechanic's lien's good for a year from the time of filing. If the contractor doesn't do anything with that lien in over a year, it expires, just evaporates in and of itself. However, that does give the landlord, the home improvement contractor, an opportunity to sue you to foreclose his mechanic's lien, to get a judgment to either be paid or collect out of having the property sold. That rarely happens, but it's the opportunity there. So the homeowner must be put on notice that if you don't pay me, I will be able to file a mechanic's lien. That notice must be in the contract. If there's a draw schedule with large projects, there's draw schedules. You pay a certain amount at different intervals of the completion of the job. If there's a draw schedule, you must include it in the contract and what the parameters are. $1,000 down payment, they're building a new house, and so it's 30% when a certain portion is completed, another 30% when another portion is completed, and so forth. And it should detail when it is that those draws should be made. Also, very important, and I do this, it protects, the law itself protects the homeowner, but knowing this will protect the contractor. So the contractor must be aware of this. The contractor must give the homeowner 3 days to cancel. And there must be a notice in the contract of the 3-day right to cancel. This is one of those rare circumstances. We talk about this quite frequently in our sessions at Cornell Cooperative Extension. But this is one of those rare instances where the contract calls for a 3-day right to cancel. It cannot be waived except in an emergency. I'll talk about that in a second. But there's a 3-day right to cancel. And here's the thing to protect the contractor. The 3 days doesn't start to run until the contractor gives the 3-day notice to the homeowner. So here's the scenario. If the contractor does not include the 3-day notice in the contract, the 3 days never starts to run. So what happens if the contractor gets done with the project? Let's say it's a $15,000 project. The contractor doesn't put the notice. The contract, the job's done, and then the homeowner says, I cancel. What's the contractor do? Well, he has no rights under the contract itself because he didn't have that provision in the contract, and the 3 days hadn't started to run yet, and the homeowner was well within his or her rights to cancel. Now, there are ways to try to get the money. The contractor would have to sue the homeowner, and then it would be up to the court to decide whether or not and how much should be paid for the work that was done. So you want to make sure, get the 3 days running. The other thing is in most instances, contractors want the 3 days to totally run before they start doing any work. Don't want to get 1 day into it and the homeowner signed the contract on the day the work started. The contractor has worked for an entire day, and then the homeowner cancels. Another problem. What frequently will happen is you get the contract signed before the work has ever started. So it might be the week before, it might be even longer before, especially for bigger projects. And then if you include the notice of right to cancel and the notice is in there, then the 3 days will have run by the time the contract started, and therefore the homeowner does not have any rights to cancel any longer. But again, it's out there. So the only exception for the 3 business day right to cancel is very narrow. And that is if this home improvement project is an emergency and the owner in his or her own writing documents the nature of the emergency and specifically waives the 3-day right to cancel. Your typical situation where that is going to occur, it has to be a true emergency, is where your furnace goes on January 4th and it is brutally cold outside. Nobody can wait the 3 days. So if that's the case and you need the emergency new furnace, you can, as a homeowner, waive the 3 days by putting it in writing, saying, I waive the 3 days because I really need a furnace because it's freezing outside. And you sign it, that's the waiver. But it has to be a true emergency. I'll use another example. Let's assume your furnace goes in July. It's not an emergency. So even if you do say, I need a new furnace and sign the 3-day waiver, then it's not going to be an emergency. It's not going to be valid. Might be a different story if you need air conditioning, but who knows? No, I don't know that that's been challenged at any point in time. So those are the minimum requirements that are needed to be in a contract according to law. If you make sure you do that, it serves two purposes. One, it complies with the law. It's probably the most important thing. But second of all, it's the right thing. It gives everybody notice of what's going on. So make sure. one of the scams, and we'll talk about that, is the guy that's going door to door trying to do home improvement work and says, hey, I got a load of blacktop right out front. I can get right in here and do this right now. They don't get written contracts. The contract has to be done ahead of time. It can't be done after the work is started. They don't do it. They end up handing a receipt to the homeowner after the job is done and claims that's what the contract is. That doesn't comply with the home improvement contract law and is a violation of the statute. The next thing that's important to understand is that any payments that are paid in advance of work being provided are considered to be held in trust by the contractor. So if the homeowner pays a down payment, there are certain rules related to this, and home improvement contractors, you really need to be aware of this, because if you violate this statute, it is a crime. There's an actual crime for under the New York State lien law for misappropriating deposited funds. It's a crime. You can be arrested and you can go to jail. So be aware of it. Any funds received for work to be performed later are trust funds. As with other trust funds, we've talked about this relating to security deposits for by tenants to landlords, which, by the way, is a plug. Next month, I believe, is one of our landlord-tenant sessions. And we'll talk a little bit about this there too, but as a home improvement contractor goes, any money held in trust still belongs to the homeowner. The only time that the contractor can use it, and the only purpose for which it can be used, is when it is to be used for, when it is used specifically for this particular job, buying materials, doing work on this particular job. So until that occurs, you, the home improvement contractor, should treat the money as if it still belongs to the homeowner. It's not the contractor's money, and therefore should not be commingled with the contractor's money. Every contractor who takes deposits should have a separate account that he or she designates as trust funds, and that only deposits that are paid go into that account. They cannot go into the general account of the contractor, into his or her wallet, into his or her own personal bank account. It must be kept separate until earned. So open a trust account at a bank. Just open a separate account at a bank that you call your trust funds. The bank may say, well, we don't open trust fund accounts. Just open a separate bank account and only put those funds in it. When you've purchased materials, or when you've done work and can be paid for that under the terms of the contract, pull the money out of the trust account and put it into the general account. It's a simple matter. The trust account, the funds, if there's a draw schedule in the contract, can only be withdrawn according to the terms of that draw schedule. This requirement in law is for the protection of the subcontractors, because they have to get paid first. So if you hire, you're a general home improvement contractor, you have an electrician that comes in, who's a subcontractor, just doing the electrical portion of that particular job. That trust funds are used to pay those subcontractors, pay for materials, and it protects the owner to make sure that the work gets done before the contractor actually takes it. Any payments received prior to substantial completion must be included in that trust account, escrow account. It must be deposited within 5 days of receipt in a bank or financial institution located in New York. Again, the property remains, the money becomes the property of the owner, and unless you include where the bank account is that the funds are being deposited into in the contract, within 10 days of the deposit, you must also notify the homeowner where those funds are deposited. And very, very important for home improvement contractors, you must keep a record of all the funds that get deposited and withdrawn from that account. If you don't do that, you could be held responsible for the misappropriation and mishandling of trust funds. That is, as I mentioned earlier, a crime. You could be arrested. And if there are no records, you are presumed, the law presumes that you mishandled the money. So you need to be vigilant about keeping the financial records of this home improvement contract. You cannot withdraw any money in excess of the contract amount, because that by definition would be that you are invading somebody else's funds. Here's the example, and this is the reason for the requirement of the deposit of the funds ahead of time. If you have 5 contracts in the works and you've taken deposits from 5 different customers and you put them into an account, you have to keep records of how much each person deposited and follow that. What we have seen happen in the past is, let's say customer 1 gave you $5,000, customer 2 $10,000, customer 3 $10,000. So you have $25,000 in the account. You're working on customer 1 job, and you pay for materials out of your escrow account in the amount of $6,000. You just stole somebody's money, because customer 1 only paid you $5,000, but you withdrew $6,000 to pay for materials. That means you took some money from either customer 2 or 3 to pay for customer 1's job. And what happened in some instances is that contractors are using, because they've overextended themselves and they've got to finish job 1 before they can go to job 2. So they'll take the money out of the account to finish off job 1 and then go to job 2. And what happens is, if you do that enough, you get so far behind that you run out of money and you've used other people's money to finish someone else's job. That's stealing money and subject the home improvement contractor to criminal prosecution. So don't let that happen. Keep records, only use the money for that particular job. The violations of just the home improvement contractor law, the fines can be up to $2,500 per violated contract. And the technical violations, just missing, failure to put in a notice of right of rescission, failure to put in what the work entails, failure to do something simple, can be $100 for every technical violation. And this is in addition to any restitution that might be owed to the consumer. So that would allow my office, the Attorney General's office, for a contractor who's repeatedly and persistently violated the law, we would be able to go into court and get an injunction, which we've done on numerous occasions, to get costs and civil penalties and restitution for damage, for violating the law and damages to the consumer. Again, the home improvement contractor can also be prosecuted by the district attorney's office for these violations. Don't let it happen to you. And consumers, know that you have the right to have a contract. And if a contractor comes to you and says, "Oh, I'll do the job," well, we don't need anything in writing. We can just kind of do it on the side. Don't do it. It's a problem. It's a violation of law. The contractor is in violation of law for doing that and can get in a lot of trouble. There are, again, many different types of scams and frauds associated with contracts. Here are a couple of words of wisdom, some guidelines to home improvement, to contract, to homeowners who want to have a home improvement contractor come in and do a job. First rule of thumb, know exactly what you want done. Make a list of the things that you want to have done and be specific about it. That will allow you to be able to negotiate with various contractors. Don't just say, oh, I want to put an addition on. You really want to know what it is so that you can go out and get estimates. You can get estimates where you match apples with apples and oranges with oranges, so you have both the contractors bidding on the same thing. And it will help you to ferret out any unscrupulous contractors who might try to convince you, oh, no, you want to do this, you want to do this, you want to do this, you want to do this. Know what you want done, and then you can work from that. We often don't know about what the rules are in having the work done. For example, certain types of home improvements require permits from your local code enforcement office. Homeowners know what permits are needed. Most of the time, the contractor goes and gets the permits. Make sure you check with your code office and say, this is what we're going to have done. Do we need a permit? And they may say, yes, you do. Make sure it's in the contract that you sign. You know that detailed contract that we talked about before? Make sure it's in the contract that the contractor will get all required permits and list what the permits are. That way, you know it's being done. They should get an actual work permit that they can put at the job site if it's required. If you don't see one around, you can call your code enforcement officer and say, hey, I got a job going on in my house, and my understanding was that the contractor did the permit application. What's the status of that? And hopefully they'll say, oh yeah, it's right here. It's all set. But if they say no, they didn't, you're going to want to stop things because that's not just on the contractor. It is on the contractor, but it's also on you. Because if it turns out this project does not live up to what the code requirements are, you could be required to tear it out, stop the work, have the work stop. So it's good to be knowledgeable about what permits are needed. Shop around, look for multiple contractors. Only use reputable contractors. Do not rely on somebody who comes to you and says, hey, looks like you need a new roof. I can put one on for you. Shop around, use reputable contractors, get estimates, get references for those contractors. Check the references out. Call the family that the contractor worked on. Maybe get pictures of it. Get proof of insurance. If a worker is injured or damage is caused to your property, you could be held liable if the contractor does not have proper insurance. Make sure that the contractor has proper insurance. Never pay heavy upfront deposits. Most contractors do not require large deposits. What you as a homeowner want to do is to always be ahead in a financial sense with the contractor. In other words, you always want to be owing the contractor, not have the contractor owing you work. So if you pay a deposit, I get it. If they pay a deposit, there's a lot of material costs up front that the contractor may not be able to carry. Then you may have to pay a small deposit, but I would not encourage you to not pay, 20%, 50% of the purchase price of the work price up front. The experience is the more the contractor gets ahead of the homeowner in the financial senses, the less incentive they have to come back. So always stay ahead. So if you put a few $1,000s down just to buy to bind you in that contract, that's fine. But make sure that first draw that you pay still keeps you ahead, because let's say if you have to pay 30% of the work, pay for 30% of the work when it's 50% completed, then you're still ahead. Don't pay large upfront fees and withhold the final payment until all the work is completed. Not, I'll get to that little part next week. Well, I'll pay you next week when it's done. Make sure that all required inspections and certificates of occupancy are finalized. So if it's a permitted type of job, a job that you need a building permit for, let's say you put an addition on the house, make sure that the code enforcement office has come out and inspected and issued a certificate of occupancy before you make that last payment. Again, put everything in writing. It's required by law, so do it anyway. Know where your payments are going, what bank they're going into. Do not do business with a contractor who is not willing to abide by these particular conditions. If they are not willing to do that, then I would find another contractor. The different problems that we have seen with frauds and scams associated with home improvement contracts are heavy upfront payments, are including not getting estimates ahead of time, not getting references and following up with them, and not getting any guarantees in writing. If you have a contractor that will say to you, "I'm fully licensed," be very wary of what that means. There's only licensing in certain specialties, plumbing and electric. So a general contractor is not necessarily required to be licensed. And if the contractor says that, I'm licensed by the state of New York, no, that's not the case. So be very careful about what's being told to you. I've had several cases over the years, most recently within the past year, of driveway pavers showing up at people's homes and saying that they can give the person a great price. I've got some leftover blacktop in the truck. I can give you a great price. The jobs are inferior when done. They cost thousands of dollars more than if you had just called a local blacktop company to have the work done. And the people disappear and you can never find them. Fortunately, we found one recently where we sued him on behalf of the people of the state of New York, but his victims were were all over the state, actually. We brought the case in Binghamton because we had several victims in Binghamton, but there were also victims in Canandaigua. There were also victims in Erie County, which is the Buffalo area, Western New York. And he was going door to door. He was convincing usually elderly people. And then he was continuing to go back to the house after he supposedly did work. And he'd say, I got to put sealer down. I need another $2,000. And we obtained a judgment against him. In addition to that, we collaborated with the district attorney's office. And he was also charged criminally for scheme to defraud and other violations as well. So it's out there, it's happening. Be very careful, protect yourselves. If you follow the items that we just talked about, you will go a really long way toward protecting yourself, making sure that you're getting the job done by a reputable contractor for a fair price and in the time period that you want the work to be done. If anybody has any questions related to home improvement contracting, I would be glad to answer them. If not, I'll hand it back to Sandy, and hopefully we will see you all soon.
Thanks, Mike, and thanks to the folks that joined us today. There aren't any questions in the chat. Mr. Danaher will be back with us on Thursday, May 13th at 11 a.m. with a program on tenant landlord rights and responsibilities. You can sign up to get the Zoom link on our website at ccetompkins.org/events. Thank you again.